May I please, my lord?
Yes.
I beg to mention item number 12. Today I supposed to file additional affidavit of other petitioners, my lords, but one of the petitioner is residing at Assam at Dibrugarh, so I could not able to contact him, my lord. So matter will be, my lord, adjourned.
Item 12.
Yes, my lord. Criminal petition for costing.
For filing application.
Yes, my lord. Filing additional affidavit of other two petitioners. Petitioner 2 and 3, my lord.
On the prayer of Mr. N. Rama.
Yes, my lord.
Learned counsel for the petitioner. List this matter after 2
My lord,
weeks.
after 3 weeks, my lord.
3 weeks?
Yes.
So as to enable him to file
Yes.
additional affidavit.
Yes. Much over.
May I please?
Hmm.
Lordship, I want to mention unlisted IA. Lordship, kindly it may be taken up along with item number 19.
19.
This IA for withdrawing the IA in item number 19.
Okay. Hmm.
Or Lordship.
Yes.
Your Lordship, I beg to mention item number 21 for an adjournment. I am
Why?
for the petitioner. I have taken the consent due to
On the
some
prayer of Mr.
M. Combo.
N. Kambo.
Yes,
Learned counsel
21.
for the appellant. List this matter after 4 weeks. 3 weeks.
3 weeks. Yes.
3 weeks.
Oblige.
Please.
Yes.
Lordship, this is
Not Mr. The case diary or records? Trial court record. Or Mr. Tito, learned counsel for the petition. Applicant. This is an application under section 483 of BNSS 23. Praying for bail in connection with Sessions case number 02 of 2024 within bracket clause arising out of Raga PS case number 14 of 2023 under section 302 of 34, IPC. Call for the scanned copy of the trial court records from the Court of Sessions. From the Court of Session Judge 80 MS L. Hage, London edition PP, APS for this too. List the matter after 1 week. After a week. We'll give the date fixed. It's a bail application. Next week when? After a week when?
After a week, Lordship.
When? We'll give a fixed date.
5th of December.
5th. 05/1/22. Yes.
Right.
Yes,
Please,
madam.
please, Your Lordship. Item number 2 and 3 are both analogous matters against the same FIR. We're praying for quashing of the FIR.
So issue notice
Yes.
and call for the
CD.
Case diary, Lordship.
Yes. Very strange.
Yes.
Yes, your SP is involved.
Lordship.
Where the SP is to be involved.
Lordship, here, Lordship.
Even if he's the friend of the informant, there appears something wrong.
Lordship, here, Lordship, informant also lodged FIR, Lordship, against the petitioner.
You take instruction of, yes,
They refused to register the FIR.
okay.
Sorry.
The informant, Lordship, that is the respondent here, Lordship. He, as per Lordship, he also lodged FIR against the petitioner. That he's been, Lordship,
On
forcefully, Lordship.
the face of the allegation, we're not happy.
The charge sheet is also there, Lordship. It is the charge sheet there, yes, sir, Lordship.
Charge sheet?
And I mean, Lordship, this FIR, Lordship, there, he already revealed
You
that.
find out
incident,
what about
Lordship,
the FIR, what happened to the FIR of this?
Lordship.
No, Lordship,
it is-
since FIR was not registered, we had filed a criminal complaint, which is
Criminal, it's
pending
pending.
now. Yes.
Pending before the court.
Yes.
Then it's okay. Third MS and the counsel for the petitioner. This is an application under section 528 of BNSS 2023. Praying for quashment of FIR number 60 of 2024. In all of PS case number 60 of 2024. Is it FIR, quashment of an FIR which has been registered as all PS case number 60 of 2024 under sections? Huh? It's in page 1. Burman, page 1 under section so and so of BNS 2023. Issue notice returnable by 2 weeks. 2 weeks. We'll make it 3 weeks. 3 weeks. List of MS L. Hagel and additional PP appears for the state. With the London Constable petitioners to take steps for service of notice upon response number 2 by register for and so within 2 days. Within 2 days. Just after 2 weeks. No, before that. After the notice, then you call for the case diary.
Case diary. Scan copy of case diary, Lordship.
Whatever. Scan copy of the case diary. Then you write, she appears person, so then just after 2 weeks. 3 weeks.
Okay.
Same order. Out of same FIR.
Yes.
Same order. But separate,
Item number 4.
Let me see your lordship.
Yes.
Lordship, here parties have already settled. Here is a case of court 98A, that is cruelty against wife. And section 490.
Husband and wife.
Husband and wife. They
Two
are
wives.
2 wives.
What about the respondent number 2? I mean, petitioner number 2.
Petition number 2.
We're staying together.
They are
No.
staying together.
Three of
No
you.
issue.
Three of you. We'll call for the case. The
This
record.
matter can be quashed because 494 and 323 IPC are compoundable. Only 498A, which is good, and it is a punishment of only 3 years.
See what's there. We'll see. Formal notice. Next date we'll see.
Yes, your lord.
Heard Mr. A. Bhattacharya, learned counsel for the petitioners. This applications jointly filed by the petitioners under section 528 of BNSS 2023. Praying for quashing of the proceedings of GR case number 849 of 2017 under section 498 within bracket capital A bracket close oblique 323 oblique 494 oblique 34 IPC pending before the which court?
London JMST UPI.
Judicial Magistrate First Class UPI. Call for the scanned copy of the trial court record. MSTs in London additional PP appears for the state. That's all. List of
I would like to draw attention of your lordship. Similar type of matter by this honorable court have.
It's okay, we'll see and we'll pass the order. All the cases are not same.
Yeah, then your lordship interim may be passed till then.
Pending production of trial court record, the proceedings, further proceedings of GR case number 8 49 of 2017 settlement state. This after 4 weeks.
Item number 5.
IA for what? IA is for what?
My lord, I have not gone through the file because for it.
Who is
on
for the
urgent
who is for the petitioner?
additional. Mr. Kodar Sadi and Jirba. On some
Not-
urgent issue, Mr.
Not
Kodar has
appears
to-
for the petitioner on appellant on call. And Mr. M. at the learned counsel appears
On behalf of M.
on behalf of Mr. M. Kato. Learned counsel for the respondent is present. This after 4 weeks.
Item number 6.
Will she inform the lawyer? Will dispose it of, will allow the petition? There's nothing.
Like,
Inform after some time. Yes,
May I please, Lordship? Lordship, this is for quashment of the FIR,
where's the offense?
offense 394, Lordship. Voluntarily causing hurt in committing robbery. This is registered under this section 394, Lordship.
394.
Yes. But Lordship, here the facts remain, no such incident was happened. In fact, the injury, as per medical report, injury was simple also. Medical report, Lordship, at page 41. 41.
41. Blunt. Simple. Yes.
And even Lordship, no
Yes.
such robbery has been committed.
Joint petition.
Joint petition, Lordship.
Pending where?
Lordship,
It's for proceedings, criminal proceedings to be set aside.
yes, Lordship. Pending before the CGM Pasigat against the petitioner number 1 and 2. 2 and 3.
2 and 3.
2 and 3. One is the complainant. What happened, Lordship, on 8/6/2022, when the vehicles of both the petitioners 2 and 3 tire got busted on the way near the Ranagat Bridge, Pasigat. And in the meantime, the petitioner number 1, he arrived on his car. Both of them, they stopped them and asked for the help. When he refused, there was some minor altercation between the parties. And out of anger only, the FIR was lost. And in the meantime, within after 22 days of the lodging of FIR, settlement was arrived between the parties. And in the state settlement, an amount of,
But this 2 and 3 committed an offense. They have accepted, admitted it.
Lordship, in fact, nothing has been robbed from the,
Yes.
at the best,
Yes, Your Lordship, the settlement speaks of the admission. However, since the parties are settled, Your Lordship,
Okay. heard Mr. K. Leonard consent for the petition, and also heard MS T.G. Leonard additional PP for the state. Next paragraph. This is an application under section 482,
Lordship,
482 of CRPC,
480.
comma 1978, within bracket, now repealed, bracket close. Filed, jointly filed by the petitioners for praying for quashing of the GR case number 112 of 2022 under section 394 oblique 34 IPC 1860 pending before the Chief Judicial Magistrate Pasigat on the basis of settlement between the parties. Next paragraph. The case set up by the prosecution is that on 08/06/2022 at 1000 hours, a written complaint was received from one Sri Uttam Sorahia to the effect that on the same day, in between 0500 hours to 0630 hours, while the informant was coming towards Pasigat from Alo via Inkyong on his vehicle within bracket Bolero pickup bracket close bearing registration number AS-07 AC-9435. And upon reaching near Ranagat Bridge, Pasigat, two unknown miscreants along with miscreants in Maruti 800 car bearing registration number AR01C-7723 stopped them and started demanding money. When the informant of the when the informant refused to part with money, one of the as demanded, one of the unknown person started assaulting him with fist and blow and with iron rod. As a result, the informant sustained injuries on his face and head. Thereafter, the unknown miscreants fled away from the spot. Next para. On receipt of the above FIR, above complaint, a case being Pasigat PS case number 66/22. 66 of 2022 under section 394 IPC was registered. During the next course of investigation, the accused person, the petition number 2 and 3, were identified. identified and arrested. Mr. Mr. The police has, it is not arrested, huh, Mr. The petition number 2 and 3 have stated to have admitted their involvement in the incident. Mr. Next paragraph. On completion of the investigation, a charge sheet was filed. Charge sheet has been filed under section 394. 394.
394.
394 IPC against the petition number 2 and 3. Mr. No, which is pending. What is the stage?
Yes, Lord, said on previous occasion, PWS was called for, but none of the PWS turned up.
Evidence.
Evidence, Lord.
The charge sheet file answering against so and so before the list of her. The stage of the it is stated that the trial is at the evidence stage. List of charge has been framed.
Yes.
Before the users, the court below has the trial court has framed the charges against the petition number 2 and 3, and the trial is pending at the stage of evidence. Next para, Mr. K. Lowell, learned counsel for the petitioner, submits that during the pendency of the trial, the petitioners have entered into an settlement where it is
Page number 23, Lord. And except 2.
23.
Yes.
Entered into a mutual settlement on 19/06/2022. The settlement without there being any question from any angle. Mr. He submits that the injury caused as per the injury report is simple. List of that apart, the petition number 2 and 3 have compensated the medical expenses which was incurred by the petition number 2 due to an injury, a simple injury caused in the incident.
27 is the payment procedure.
Mr. Therefore, it submits that since the matter have been settled between the petitioners, there is unlikelihood of any evidence against the accused persons, and as such, the continuance of criminal proceedings would be futile, as there would not be any, as the chances of conviction are remote. And as such, he submits that the criminal proceedings may be present criminal proceedings being GR case number so and so, huh? Right? Being GR case number so and so may be quashed. MST learned additional PP clearly submits that since the parties have settled the matter and the injury caused is simple in nature, she has no objection. She has no serious objection for quashing of the present criminal proceedings, as same would same may end in acquittal for want of evidence against the petition number 2 and 3. Next paragraph. Having considered submission of learned counsel for the parties and also on the scrutiny of the trial court reports, it is seen that the petitioner and petitioner number 2 and 3. What is their age?
Petitioner number 2 is 31 years old,
No.
and petitioner number 3 is 32 years.
Petitioner number 2 and 3 have
15 and 18.
admitted the involvement. Admitted their involvement in the incident before the police. Accordingly, a charge sheet has been filed against Mr. However, the incident, the injury caused as per the injury report reflects of simple in nature. Next paragraph. During the pendency, the parties have entered into an agreement as noted above, and they are stated to the petitioners are said to be living a cordial, they are having a cordial relationship among themselves, between themselves, among themselves, sorry. Next paragraph. Having considered the not sorry, on the consideration of the entire matter, consideration of the matter in its entirety, I'm of the view that no useful purpose would be served in allowing the in continuance of the in allowing the continuance of the present criminal proceedings as the parties have settled the matters listed. Even if the petition number 2 and 3 have said to have admitted their involvement, in view of the settlement, it would be there would not be any evidence against the accused. Public petition number 2 and 3. Just in the event the proceeding would be an abusive process of law. Mr. Next minute. Considering the above, I deem it appropriate to allow this criminal petition stuff accordingly. The criminal proceedings of their case number 112 of 2022 under section 394 of IPC pending before the learned Chief Judicial Magistrate Pasigat is quashed. Criminal petition stands allowed in disposal. This is a scan copy or what?
No, yes, Your Lordship, can.
No need to send it back.
No.
Yes.
Lordship, here, this is the Pasigat PS Lordship. Again, another matter, item number 9 is Alo PS. In Alo
Yes.
PS, we have not received the case study Lordship.
There's an interim allops. But Pasigat will.
Pasigat is here, Lordship.
Yes.
Lordship, here, Lordship, it is reflected that he's already in the custody in the Konsa PS Lordship.
Yes. So,
Lordship, here, Lordship, actually, Lordship,
so what is the law? If a person is arrested, already in custody, will the anticipatory application will be maintainable?
Lordship, because this is another PS case, it can be Lordship.
That's why I'm asking.
Yes, Lordship. But the thing is, Lordship, here, Lordship, one order was passed, Lordship, on 6/11, Lordship, whereby the AB was the earlier granted interim was vacated because the person did not appear, Lordship.
When
The
a person
condition
is
was-
arrested
Lordship.
in the custody, how can he appear?
Lordship, that's why in the similar, in the same matter, it will be similar, Lordship, because the
So
AB.
what is the procedure, madam?
Lordship, here, Lordship, if he's already in
If a
custody.
person is arrested
Lordship.
in custody in some other place, in some other case, maybe related or not, what is the procedure?
Lordship, these cases is different.
What the police has to do?
Lordship, police has to do, Lordship, because in this.
What is the procedure? What police has to do in that case, in that situation?
Lordship, here, Lordship, the cases is different, Lordship, in different PS, Lordship. So, Lordship, here, Lordship, the thing is, Lordship, here,
Madam, I want to know what is the procedure when a person is arrested in a different case.
he can
in a
be remand
custody.
he asked for the remand, Lordship. He already, Lordship,
What
in-
remand?
for the accused person, Lordship, for the affair before the Lordship and to submit his statement, Lordship. Here, Lordship, in the Lordship case diary also, he is requisition sent to the SP Pasigat to trace the record of it and to the judge's power and to produce before the PS, Lordship. It can be done, Lordship, although he is in the custody of the Konsa PS. Because, Lordship, his Lordship, not only this, Lordship, his several cases is there, Lordship. In the ALO also there,
Several
Lordship.
cases, some of the cases, same cases, multiple affairs,
Lordship,
and then in some cases, he has been released on bail.
Lordship. A release on bail, but the thing is already in custody, he could not appear before the PS, Lordship. And apparently, Lordship, his bail, this interim was already vacated, Lordship. Also vacated. He's the
in this case.
Yes, Lordship.
What is this case? That is
There is another case, Lordship, but the accused person is same.
how not that he failed to appear because he was at that point of time, he was inside the gate.
So Lordship, in this case, this AB can be kept pending, Lordship, because Lordship, if the interim also granted, it out of the no use, because it's already in the custody. He cannot appear before the IO for the statement.
This is which case? Pasigat PS case. Under section
Oh, 318, Lordship.
318.
Now the
Oh,
project.
sorry, Pasigat is Lordship, 420, sorry, 420 and 406. Hello is for 318, yes, Lordship.
What is the status?
So status is remain the same, Lordship. He cannot, he did not appear before the IO and the Lordship, his Lordship.
That is precisely, madam, I'm asking what is the procedure in that case? Just because he is
In the Konsa PS is.
he is detained or in custody in some other cases in some other place. You'll the police will put your hands up that he is already in custody. Is it not the duty of the police to abide by the procedure?
Lordship.
That is what we wanted to know. That is what we were asked for the status report.
Lordship, status report is here, Lordship. Here is it informed that it is
Is it a
informed.
law that suppose if a accused is arrested in some other place, put in the custody, so the cases will not move until the time that he is freed from the other cases in other places?
Otherwise, but Lordship, it can be whether it can, if Lordship
As
is.
if the police is only duty is only to arrest their accused. Is it so?
Lordship, that's why Lordship, he arrested and even he granted bail, Lordship, because 420 and 318, Lordship,
It's of 7-11. Today is what?
today is Lordship, 28, Lordship.
28. That's the reason we asked for the status.
Lordship, this much only they have sent,
Updated.
Lordship.
Updated.
Yes, Lordship.
You have not received.
No, sir,
Otherwise-
I have asked for the update that, but the IO of this matter, Lordship, he's in duty in the RGU, Lordship, for the passenger petition, and that's why, Lordship, he sent this much, Lordship.
Madam,
After
we are
that,
not
no.
concerned about where he is. If
Lordship,
he is in holiday,
Lordship, his update case there could not be maintained because Lordship, he's in
reason
under.
is very simple. We are fixing this matter every after 2 days.
Lordship, he's in another Lordship PS is already in the custody, Lordship. That's why, Lordship, he could not
Madam, I
appear
have
before
heard that submission up to number of times.
the.  'Lordship,
What
the-
I'm asking is, I'm repeating it again. Finally, you just listen it. If a person is arrested in some other case, in some other place, there is a case against him in other place. What is the duty of the police for investigation of that case? What is the procedure to be adopted?
Lordship, in the Lordship that, in that case, Lordship, he can, Lordship, ask for the remand, Lordship, for the, from the concerned PS, Lordship, where is it detained, Lordship. That can be done by the investigation agency, Lordship. Because here, Lordship, if the AB is moved, they have moved the AB before this honorable court for the granting interim, but the Lordship, if the interim is granted also, Lordship, he cannot appear before the IO for the statement. That is their Lordship. That's why, Lordship, I am praying this honorable court that let the AB, Lordship, it may be disposed that it is he is already in the custody in the another Lordship PS Lordship case. So this is not, or otherwise it may be kept pending, Lordship.
You are not, you are adamant not to tell.
Lordship.
There is a procedure called production
Lordship, there's a production, Lordship.
Production warrant.
warrant.
That's why, Lordship, they have applied, Lordship, already applied, Lordship, before the concerned.
Can you tell us that?
Lordship.
So we'll allow bail in this case. In the event of arrest, he shall be released on bail. That's all.
Yes.
Heard Mr. Tita, counsel for the applicant. This is an application under section 438 of CRPC 1973. When did you file this application?
There is slide 482 DNSS.
It's either of the two,
It is,
not the both.
I was, at that point of time, I was not aware of that, TV owner, that is
You
why.
just write under section 482 of
482.
BNSS
That was my
2023,
482 is the very
praying for grant of privilege of pre-arrest bail to the accused person, namely Sri Dheeraj Paul, in connection with Pasigar PS case number 115 of 2023 under section 406 IPC 1860.
420, 406.
You have said, you have given only, where is the FIR?
FIR I have enclosed now. FIR is page number 17, annexure 2. Complaint. In the complaint itself, it is reflected nearby the.
Under section 420 oblique 406 IPC, huh? Next paragraph. The investigation has been set into motion on the complaint oblique FIR filed by one Sri Takin Pago of Korang village, East Siang district. On the to the effect that and a huge scheme is in operational, in which the informant was fraudulently made to transfer his hard-earned money amounting to rupees 10 lakhs by by the accused, namely Sri Dheeraj Pal of Dhemaji district and a proprietor of Messrs. M obligation, Rhodes States Private Limited, Guwahati, in connivance with some other person. On connivance, one Sri Prasad Misra, list of Prasad Misra, who have jointly convinced the informant during the mid part of 2022 that the tender work for the construction of Telecom tower in East Siang district, West Siang district, Upper Siang district, the Siang district, and Lower Siang, Lower Dibang Valley shall be awarded to the informant as their firm has been awarded the tender work of erecting telecommunication tower throughout the northeastern states. Please do. The informant initially handed over an amount of rupees 2 lakhs on 24/09/2022 and then transferred an amount of rupees 8 lakhs on 13/10/2023 into the account of the accused Sri Dheeraj Pal. Being SDFC bank account number 50100326106198. Mr. It is alleged that the accused, after receipt of the payment, as demanded by him, has started avoiding the informant list of. There was no allotment of the award in allotment of the work, and it is only during the month of July 2023 when the telecom tower at Korang village started by another company, the informant could sense foul play and demanded money back from the accused, who has again asked for more money from the informant. It is stated that despite repeated requests, the accused has failed to transfer the amount back, thereby has cheated the informant. Next for accordingly. On receipt of the said complaint, an FIR was lodged, FIR was registered, being Pasigat PS case number 115 of 2023 under section 420/403 IPC. Mr. Where is this page 19?
This 19 is, this is another, this is.
Okay.
Another FIR, this is not in this case, but in another case. Regarding sitting. But
Mr.
this is
T. Tapak,
simple-
learned
simple-
counsel for the
simple case.
applicant submits that the accused is the representative of the MS Rhodes
Rather,
uh,
state private limited.
Estate Private Limited, who has no role to decide the transaction. This stuff. The informant has there is a contract between the company
Private company.
private company limited, a private company in which the accused is simply a representative. This stuff. There is a contract between the informant and the company for which an amount admittedly has been deposited by the informant. This stuff. Therefore, he submits that on the face of it, the FIR discloses, FIR doesn't disclose any criminality, rather it's a purely civil dispute between the company under which he is a representative and the informant. This stuff. Next paragraph. He fairly submits that there are multiple FIRs being filed against the accused in the state of Arunachal Pradesh, where DG, in view of the breach of contract between the company under which the accused is the representative and other persons who are involved in the business transaction. List of. He also informed that he has also informed that the accused presently has been arrested and is in judicial custody in connection with
It was earlier in the Simple police station case, and then it was on warrant, protection warrant at the Sanglam.
he was arrested here.
Yeah, I was arrested.
He was arrested in initially, no,
Simple police station
he
case.
stated that the accused has already been arrested in other cases and presently under the judicial custody at
At the Sanglam police station.
now Sangram police station. Now Sangram,
Now Sanglam.
he is there in judicial
yes.
custody at Sangram,
Sanglam.
at Changlang.
Sanglam.
Changlang, police station. This court on various
Not super, not Sanglam, it was a Devmani.
Devmali, at Devmali, in place of Changlang, we just right Devmali. This court has directed on several occasions, on several dates. This court on several days has directed the learned additional PP to produce the case diary and place the updated status report in connection with the present case. Even after receipt of the, this is case diary,
No, sir.
receipt of the case diary
Along with the
dated
status
12
report.
11/2024. Next one. Today, learned additional PP, while referring to the
Lordship, this is
order passed by this court in AB number AB 121 of 2024. This is in connection with which case?
Itanagar PS case.
Wherein,
It must.
Pasigat PS.
wherein
Not Pasigat, Itanagar PS. Abhika Pasigat.
The order where it is vacated, Lordship, that is Itanagar PS case, Lordship, Kimpu case.
Simple way, in connection with another case that is simple illustration of one goes to one square, given the entries of one family. It submits that despite the interim bail order by this court, the accused has failed to appear in another case, i.e. Itanagar PS case or Chimpu PS
Kimpu
case.
PS case.
Itanagar PS.
Itanagar PS case. Which one is correct?
There's so many, Itanagar PS case, Lordship.
In Itanagar PS case,
Yes, Lordship.
in Itanagar PS case, I have understood you are not, both of you are not in tandem on facts. Please stop.
There's so many cases. Lordship.
The bail application, the interim bail application was not extended. Although the learned counsel for the petitioner in that case has submitted that in view of the arrest of the accused, in another case in Chimpu PS, case number 09 of 2024, he was arrested. Therefore, she submits that the accused is not entitled to the privilege of free arrest bail in this method, as there are many cases being registered against the accused in many parts of the state. Next paragraph. She also submits that in view of the arrest of the petitioner in the Amali PS case, who is under judicial custody, no arrest or investigation could be progressed. No arrest could be made, and investigation is not progressed further. Please stop. Next paragraph. On consideration of the records submitted by the learned additional PP, it is noticed that no serious attempt has been made to investigate the present case on the on the pretext of the accused has been arrested in another case, i.e. Demoli PS case, and he is in judicial custody at Demoli. It is not understood that the police police has no knowledge of the procedure in such circumstances it is not understood why the investigation has not been proceeded further, just because the accused is arrested and put and arrested and is under judicial custody in a different place in another case. Different place in other case in a different case.
Lordship, may I, Lordship, sorry for interruption, Lordship. Here, Lordship, in the case study, Lordship, it is reflected that they have pair being made for the production warrant of the alleged accused person and request to show him before the Lordship, Honorable Court of CGM Pasigat. They have already, Lordship, discharged this step, Lordship. On Lordship, 22nd October, Lordship.
Why have not pursued that?
Lordship, that's why, Lordship, after that also, Lordship, it has not been pursued, Lordship.
Well, that is your duty.
Lordship.
It's a police duty. Mr. We'll continue.
Lordship.
We'll come to that. Except informing that a prayer has been made for production warrant before the appropriate court, before the competent court, before the appropriate court. There's nothing on record to show that the police has serious in its duty to pursue the matter. Although MS El Hagel and additional PP has submitted that police has already prayed for production warrant of the accused, there's nothing on record to show that any serious any action has been any action had been initiated by the police for proper investigation of the matter. Next paragraph. Records on perusal of the FIR, it appears that the dispute is of civil nature, as the same regards to contract of for construction of for erecting of towers, wherein the company and the informant has entered into an agreement. List of be that as it may, this states we're not this court is not commenting on the veracy of the FIR, public complaint. List of, however, on the face of it, it appears to be a civil nature, although certain a negligible element of cheating has been alleged against the accused. Having considered the materials on record, I'm of the view that the petitioner, the accused, is entitled to the privilege of pre-arrest bail in the present case. Next, accordingly, it is provided that in the event of arrest, the accused, namely so and so, Dheeraj Paul, so and so, in connection with Pasigat PS case number so and so, shall be released on bail on furnishing a bail bond of rupees 50,000 50,000. 50,000 to the satisfaction of the arresting authority on the
Lordship,
following conditions. What are the conditions?
Lordship, that he will, Lordship. Condition, Lordship, he always, Lordship, broke the condition, Lordship. That's why his interim already, earlier occasion vacated. Lordship.
That's why I said in the event of arrest. If
Lordship,
he's not arrested,
if-
there's no question of bail.
Then, Lordship, if he, Lordship, if condition fail, then it's maybe
Uh,
stay
the-
vacant, Lordship.
It is expected that the investigating authority shall, mindful of their duties and responsibilities in such an investigation, which has mindful of their duties and responsibilities in the
Yes.
matter,
Lordship,
in the case. Please stop.
Lordship, may I, Lordship, because Lordship, as
It is
per the
further
Lordship,
provided that any observation in the present case shall not be taken as a view of the, shall not be taken as an observation on the merit of the present case or the other pending cases. List of bail application allowed and disposed of.
Lordship, may I, Lordship, as per the case study, Lordship, they have already applied the Lordship, CGM, Lordship, for the production warrant. Lordship,
Then
but-
you will sleep.
No, Lordship, after that,
You'll go
Lordship,
back
the
and you'll
duty,
you will
Lord-
just apprise the CGM and ask for a production warrant, and then
Lordship-
you'll go back and sleep.
actually, Lordship, after that, Lordship, it production
When
warrant.
it was, just
Lordship,
tell us
it
the
is,
date.
Lordship, on 21/11, Lordship, here
Yes.
the updated CD is there, Lordship, where there's a CD, where the case is pending for reply from the CGM Pasikat, Lordship,
Yes.
which already asked for the
So
production
you
warrant.
will-
After that, the CGM,
you will wait for the reply for all time to come.
Lordship, actually, the CGM court also passed the order for the production, Lordship.
Or CGM court.
No, I'm not blaming us. This is the procedure. There's a lapse of the Lordship, this procedural Lordship. Only that part, the investigating agency have done his duty, Lordship. After that, Lordship, CGM court, Lordship, their
Should I
reply
make-
awaited,
Should I
Lordship.
make more observation?
That also can be, Lordship, because this awaited is from the Lordship, CGM court, Lordship, for the protection. The investigating agency have done his part, Lordship.
In support of the, should I
Lordship,
recommend
Lordship, kindly, Lordship.
observation?
Kindly, Lordship. Because, Lordship, only that part, Lordship,
No, I am
awaited.
making more observation on your submission.
Lordship, because what is in CD case study, Lordship, I am submitting that only, Lordship, fairly submitting, Lordship.
That's what I'm saying. You have done that I have recorded. But then you have to go further.
No, Lordship, it's not,
Investigation has to be progressed.
not necessary, just for the affairs of this court, Lordship, I am submitting this, Lordship. That's
Okay,
what-
thank you.
Obliged.
That is also similarly situated.
Last case study is not here, Lordship.
We'll have to see the
Yes,
case.
interim order already granted.
I heard Mr. So-and-so, date of a learned counsel for the petitioner, the applicant, MS El Hage, learned counsel, learned additional PP, submits that she is yet to receive the case diary. Therefore, press for some time to obtain the case diary. List the matter after
3 weeks.
Huh?
3 weeks.
After
4 weeks.
after 2 days
2 days.
you obtain. Why you are
Next
3
next
weeks?
week, Lordship.
After a week.
Lordship,
After a week.
obliged, Lordship.
Don't try to take advantage.
Oh, bless.
Yes, what is to be done?
My lord, this is a case in which this is an FIR by the father-in-law of the girl against the daughter-in-law.
Well, listed for today.
It is, my lord, it is observed that it is this understanding that it will be.
This is the
heard
matter along with on which date the company shall produce the updated case CD. In the meantime, the case given the record is 10 on accused person for BC. The interim order person shall continue.
Mhm.
Very small matter, my lord. The
Yes, who else shall appear?
Pardon me, I'm appealing for the applicants,
For the petitioners.
for the petition.
And who is for respondent number 2 and 3?
I'm appearing for respondent number
Is
2.
they online? Through VC.
Hmm.
I'm for 3.
What is the matter?
My lord, the interesting thing is, the marriage was solemnized on 21st of November 21. I've placed this event on record, my lord. It must be there on the last date of hearing. Now, my lord,
Sir, this is listed for orders, will listed for admission, will dispose of the matter. Whether you have received the CD?
Lordship, it's updated case. There is updated case is here, Lordship. As per the case, there is Lordship. CDR analysis report is the report is awaited, Lordship. That's it, Lordship. And the statement of the
What?
CDR, Lordship, the telephonic, Lordship, they
CDR.
have, Lordship.
CDR.
statements have been recorded. I'm making a statement at bar that IO has recorded all the statements through video conference.
Yes.
Yes.
I'm making a statement at bar.
What is the offense?
But
Offense is
interesting it is. Father
Sir, let us fix it for some other day because this is listed.
All the
No,
way from Delhi. my lord.
sir, it is listed for orders.
My lord, they can see the order sheets, last to last order sheet, my lord, with this understanding that it will be decided finally. You have the order sheets with you.
No, there is nothing like this. Last order is 811.
Before that, my lord, I was physically present here, my lord, and it was observed in the order. My friend, I think that you don't have.
Which one?
the order.
Which order? Last order is
Just check the
811.
date When I had gone to make it. It is 310, my lord, 3rd of October.
Thereafter, so many cases.
3rd October, thereafter it was 16 September
3rd of October.
and 16th September. My lord, it is a small case, there's nothing. My lord, it's kind of.
Sir, all the cases are, there's no like big or small cases.
You don't have a copy of the order sheet.
Right. What is the urgency?
My lord, urgency is. Their husband, wife.
The interim order is operating in your favor.
What is operating, my
So
lord?
what
She
is
staying
the urgency?
2,000 kilometers away. Now, my lord,
Is
the
it-
husband and wife, they did not get along well. I know, very interesting.
Sir,
Husband and wife.
200 kilometer from where? 200 kilometer from where? 2000.
She's
Where,
in
sir?
remote district of state Chhattisgarh.
It's the beauty of our state. It's the beauty of our nation, huge area.
Yes, definitely, my lord. But it's painful for the people who've been falsely implicated. The complainants don't stay here. Complainant stays, my lord, in Withdrawal, near Delhi.
Yeah.
The girl stays in Raipur, Chhattisgarh. Her parents stay in Madhya Pradesh. Now, an FIR came to be lodged, my lord, after she filed a divorce petition. And the divorce has been decreed now. Now, husband doesn't come forward. But if this Bhaluk Pong, the father-in-law files a petition, lodges a complaint against the daughter-in-law and all the family members.
Who is this respondent number 2 and 3?
Yes, my lord.
Yes.
In this case, otherwise, the whole the offenses sections are available. What the accused was supposed to do was only appear before IO and give recorded their statement. The difficulty here is they are just they had an apprehension. Even if they had
Sir,
a
this
genuine
is-
apprehension.
Sir, this is for quashing of the FIR.
Yes. With regard to, I am submitting with regard to the interim which is operating in their favor, my lord. My lord, they have somehow
He is
obtained.
for final disposal. Learned senior is for final disposal.
Yes, otherwise,
Why-
my
why
lord,
now?
in this case, without asserting the whole detailed record of the accused, this matter, updated CD, without updated CD, this matter cannot be disposed of.
May it please your lordship.
Yes.
First of all, I apologize, lordship, that I'm appearing online due to my health condition. My lord, not feeling well. My lord, there is an IA that I had filed. My lord may just pursue the IA once.
We'll go by this is listed for orders. We'll go by the order, last order of this court.
Yes, my lord.
Why
As-
why not? What is the updated CD? Show us.
Is this here, Lordship?
Directed to produce the updated CD.
Lordship,
This 2611.
Lordship. Day before only we have received this.
Sir,
updated
we'll
message.
check it out because last order we have asked for the updated CD. That is the real reason for adjourning it for some other day because you all the accused have been the statement has already been recorded through BC and they have the
CDR record.
CDR analysis report is required. So yeah, their CDR analysis report is required. Yes, so they are waiting for it. So we'll fix other some other time.
And the fixed rate could be.
Yes. Heard Mr. M. Singh.
Again the same.
M. Singh, learned senior counsel assisted by Mr. H.K. Jama, learned counsel for the petitioners. Also heard Miss also heard Mr.
SP Sharma.
Mr. MSL Hage, learned additional PP for the state.
For respondent number 3.
Then rest 2 and
I for respondent number 2, man.
Mr. Who is this? Mr.
SP Sharma.
SP
SP
Sharma. SP
Yes, sir.
Sharma for respondent number 2.
R for 3 and
Sir,
E for
sir,
4.
T. Omo for respondent number 3 and Mr. Ubori for respondent number
calendar.
That's okay. Omo for 3, huh? Then 4. Ubori. As per the order of this court, that is 08/11/2024. MSL Hageland additional PP has produced the updated case diary, sir, which indicates that a CDR analysis report has been prayed for so as to ascertain the telephonic communications between the alleged accused and the victim.
Only possibility.
And the same is and the report is awarded
If I'm there,
in view of the book. By considering above that this matter be listed after 2 weeks, when you are expecting the report,
Lordship,
2 weeks,
Lordship, if it not come at that time, then Lordship,
when
It's
fix it?
appropriate.
When will fix after 2 weeks? On which date? After 2 weeks?
23rd or 24th of December, that will be around 4 weeks.
4 weeks.
So
4
we have
weeks.
sufficient time.
4 weeks, huh?
23rd or
4
24th.
weeks.
24th, Lordship, 24th.
fixed date.
23rd, Lordship.
On which date the learned additional PP shall place the updated case diary
Last working day.
including the CDR report.
Sorry.
This is the matter of 23rd, 12th, 2020. Highly obliged.
Obliged.
That's all right.
Yes.
May I please, madam?
Yes.
Madam, this is a joint application, madam, under 482, madam.
The husband and wife, we are allowed petition allowed.
Obliged.
Heard Mr. M. Doji learned consent for the petitioners and MS El Hagelan is for this.
Obliged.
Obliged.
Dispose.
Please, Your Lordship,
Yes,
I'm appearing for the appellant as legal aid counsel.
yes.
The office note says that respondent number two's service has not been returned and
Paper book is
paper book is under process.
Heard MS El Hagelan legal aid counsel. Mr. For appellant. For appellant.
Appellant.
Office note that is 27/11/2024 reflects that the paper book is under preparation and service report in respect of the victim is still awaited. List the matter after 3 weeks.
Obliged.
May I please, Lordship?
Take press steps. Have you taken press steps?
No, Lordship. We'll take press step.
Mr. Learned counsel for the petitioner is permitted to take his press steps with service of notice upon respondent number
2.
Respondent number 2 within 2 days. List after 4 weeks.
Okay.
If you. Your Lordship may, in that case, also call for the updated CD on the next day.
MST the London SLPP is present in item 11, right?
13, Your Lordship.
13. Will call for the
The, updated CD. Your
call
Lordship.
for the updated CD. Yes. 14.
Here, my lord, I was supposed to be in instruction, my lord.
Yes.
I've received the instruction, my lord. Here.
Yes.
Para 2, my lord. Since my Chindra village has only 1 GB, my lord. That's why it was forwarded to Soy village, my lord.
Only 1 GB.
Yes, my lord.
Rohit Basar and who is close relative of Sri Gogam Basar.
Actually, other GB expired.
Who is Gogam Basar? Respondent.
Yes, my
Yes.
lord. That's for number 3.
It's fair. It's fair enough.
They are
There's only 1 GB and the GB is related to
The
relative
respondent.
of the respondent.
they are saying
There's the likelihood of bias.
they are saying, I'm not saying. Lordship, if it is,
That's why they are saying it's correct. It's fair enough.
Lordship,
You appear.
Lordship, if that is the case, then we'll go for civil court.
Huh?
We'll redress our grievances before the civil court, having jurisdiction.
So you want to withdraw?
Yes.
Withdraw the petition.
Matter may be disposed of. Lordship.
No, if you are withdrawing, we'll allow.
No, I'm
We'll
not,
provide you to, we'll provide that the liberty to approach the civil court.
Better maybe dispose.
No, it cannot be. If you dispose of, we find it's fair enough. Entrusting some head governor of the other village, when only one GB who is relative of the respondent.
Lordship, in fact, that Hanken Basar is also related to this.
Then I don't know. We're concerned about it. There's no pleading there's no pleading that Hankem Basar is a relative of the. Is there?
Yes, of course.
Where it is?
No.
No, madam, it's
I'm
not there, madam.
I have not mentioned.
Once you have not pleaded, how can we accept?
No,
that?
these two, in their instruction, they have pleaded that that the
Toy Basar is a relative of Gogam Basar.
yes, they are claiming. They claim. They are saying.
So they are not saying that he is the relative of yours.
Yes.
The relative of your opponent. So to avoid the likely biasness, they've been entrusted to some other Gopura. And it's a genuine, and it's fair.
Since as per section 5 of this 1945 regulation.
Suppose in such situation, can you say that it is so static that DC or the authorities cannot?
Under section 5
Suppose a dispute has to be decided. If there is only one person who is related to you, will you ask for the one person to be decided your case? Will you ask for that?
No.
Then it's the same case here.
But it's their claim. No.
Authorities are fair enough.
That's it. I pray that this corona maybe
No.
caution, like we'll go for
Unless we are satisfied that this is there is a certain ground. We are satisfied that ground is very reasonable and very fair.
we'll file reply.
You bring on record
Yes.
in that case.
We'll file reply.
And my lord, there is stay also, my lord, and that cover.
That
proceeding
will
was-
continue. That will continue.
They have already stayed. We'll file reply also.
You you file within 1 week. We'll list the matter after 2 weeks. We'll dispose of. All right. And then ultimately you have to go to this people.
No.
Unless you can establish that this Hanken, if that is the case, you have to file an application before the deputy commissioner again.
Yes, Lord.
That you appoint some other person other than this Hanken Basar or something like that. Right.
We'll file reply.
In that case, they may change it.
Yes, ma'am.
Pendency, I'll provide that you may you may approach the deputy commissioner.
Also.
In case, if it is established that the Hanken Basar is also a relative of what that
Ambassador.
Gogam Basar or a relative of any other party, either of the parties, will say.
Lord, sir.
Heard Mr. T. Taba, London Council for the Petitioners. Petitioner in person. As per the direction of this court, MS T. Wangma, London State Council, has produced the instruction which indicates that the dispute has been referred to the head GB of Soy village, namely Sri Hanken Basar, as the lone Gabura of Chinne village, who is a close relative of the respondent. Christopher. In this list of on such instruction, Mr. Titaba, learned counsel to the learners petitioner in person, petitioner in person, submits that Sri Hankin Basar, head GB of Soy village, is also a relative of whom?
Petitioner.
Yours.
No. Respondent.
A relative of
Gogam Basar.
respondent. Therefore, he also cannot take up the matter in the if take up the matter if the matter is entrusted to the head GB of head GB of Soy village on the ground of the lone GB being the close relative of the respondent. Considering the vote, the petitioner may approach the deputy commissioner for appointment of the other head GB of other village, of other village.
Lordship,
Another head GB of
Lordship,
some
that is
other
not my
village.
prayer. That is not my prayer.
Others, yes,
That is not my prayer, Lordship.
this is order of the court.
Lordship.
We're directing you.
Lordship.
All right.
Yes, Lordship.
What is it? No, considering the submissions, considering the above instruction and submission of land consent for the parties. Pendency shall not be a bar for the petitioner in person to approach the deputy commissioner for appointment of other head governor / GB for adjudication of the matter. If it is established that Sri Hankin Basar HGB of Soy village is a relative of the respondent, the respondent may bring on record the but affidavit will be true suffice. We'll ask you to furnish this.
Oh, I've
We
already
have
finished.
already received.
You have received.
Yes, just now.
Anyway, you will bring on record. The MS T. Wang Learned State Council to bring on record the instruction by one affidavit.
Interim medical.
Interim order first, and yes, will continue.
If
Sir, it appears to be unnecessary. You want the adjudication of the matter?
Yes, before the civil court, Lordship.
Go there, who is stopping you? Who is stopping you?
During the pendency of this Parwana, there may be technique. We cannot approach before the civil court because.
But we find prima facie on the instruction, the deputy commissioner is correct.
Lordship, if this Parwana is still pending, we may not be able to approach before the civil court. That's why my prayer is there. If this is disposed, then we can approach before.
We just cannot set aside or dispose of like that.
Okay.
There must be some reason why we're interpreting the Parwana.
Because
the reason furnished appears to be very, very fair.
Lordship, as per section 5 of this regulation.
Don't schooling me on section 5.
Lordship.
I'm conscious.
Because Chirnai village is different village and Soy village is different village. So
please stop schooling. Thank you.
if
Yes,
May I please, your lordship? My lord, I am appealing for respondent three.
yes.
I am filing objection today.
Okay,
Lordship, can it be taken up on coming Tuesday?
okay.
Tuesday?
Or Mr. So-and-so, learned counsel for the petition.
Third.
Or also MS T. learned additional PP for the state. MST Dungan learned
And
counsel
Duncan.
enters appearance on behalf of respond number 3.
Yes.
Oh, sorry, N. Duncan. And praise for sometime to file the objection. List of praise a lot. List the matter on
3rd of December, next week.
03/1/2024.
Oblige.
My
What is
place,
this?
Lordship.
Lordship, can I take up this matter?
Yes, Lord.
No,
He can.
I cannot.
Yes.
So what happened here was, when appeal was pending, the amount has been pending, his pending bill. Amount has been not released to the other party.
Yes,
The
Lord.
substance state has become important.
So what is the IA?
IA is calling of all those.
It is substantially or it has become infructuous?
On merit also, still appeal is there.
Okay.
But
Once
on-
release, consume everything. So it will be very difficult to recover. We'll close it. As infructuous. It is submitted. No. Mr. Estapit Leonard, Senior Government Advocate for the appellant, and Mr. K. Leonard, Counsel for the respondent, have jointly submitted that matter has become infructuous as the payment has already been released to the respondent.
Yes.
In view of the above, the appeal stands disposed of as infructuous.
Lordship, part payment.
No, not part payment. Therefore, also, if my friend is insisting for part payment also.
We'll not say anything in that case. We'll say, as have jointly submitted that matter has become, the appeal has become infructuous. That's all. Whatever you want to do, do it.
Then in that case, also, if I think decree will revive again, so for the part.
Yeah.
But we are against the internal process decree. So therefore, also, since my friend is process part payment, then I'll produce one document where he has written to the authority. As per the direction given by the solo purpose, records was formed and this records. Where it says also.
Correct.
Telecom to page 2 also. Paragraph, the second paragraph, therefore, I am to inform you that I have received the check amount of rupees so and so. Latest so and so, after deducting necessary government revenues, after going through the details of all payment related documents as per the office record. I am fully satisfied with the payment made by the executive engineer. In the instant case, I will never claim the unpaid balance amount, almost raised from now and forever. This is the lawsuit, one lawsuit writing of the present respondent. And this had happened during pendency of this appeal.
So how much you have received? 2 crore. What was the amount?
Decretal amount was, Lordship, 4 crore 25 lakh 67,032 rupees. Out of that, Lordship, during pendency of this appeal, RFA, 2 crore 13 lakhs was paid. So this, and out of that 2 crore also, Lordship, the department, they didn't pay some portion of amount. Accordingly, this FIR was lost. And this FIR was in relation to the part payment made to this present respondent, Lordship, not the entire amount.
Withdrawal of the FIR.
Yes. This is regarding the part payment made to the present respondent only, Lords. This, Lordship, here.
No, you
Lordship,
have said after going through the details of all payment related documents as per office record, I am fully satisfied with payment made by the executive engineer. In the instance, I shall never claim the unpaid balance amounts and I will not raise from now and forever.
This is regarding in same para to Lordship, the amount has been mentioned, 2 crore 13 lakh 7. This is the part payment that made by the department.
No, that's what I'm saying. Therefore, I am to inform you that I have received the check so and so after deducting necessary revenues. After going through the details of all payment related documents as per office, I am fully satisfied. You have to continue. Read
Here, no, Lordship. Out of that decretal amount was 4 crore 25 lakhs, Lordship. Out of that amount, the department issued a check of 2 crore. And out of that 2 crore again, now they have deducted some necessary deduction. And then they paid a 1 crore 13 lakhs. This FIR pertaining to that part payment on made to the respondent only, Lordship. Not to the entire decretal amount. Entire decretal amount was 4 crore, Lordship.
No, I am fully satisfied with the payment made by the executive engineer.
Yes.
In the instant case.
This is regarding the 2 crore part payment.
I shall never claim the unpaid balance amount and I will not raise from now and forever. What unpaid balance means?
Out of 2 crore, Lordship, what happened? Department again, they paid half portion of the amount again. For that, FIR has been lost. Now, after losing of FIR, that remaining balance of out of half payment was made to the respondent.
So, according to you, it has not become in process.
Yes. To me, Lordship.
Yes, I submitted because as he agreed earlier that it can be closed as in process. Therefore, I have plainly I have submitted those. Otherwise, this matter will be here on very close. If my friend is insisting again, because he agreed, therefore I have submitted it can be closed as in process. Now he's changing his.
Yes, I am claiming for entire decretal amount also. It was total 4 crore. Out of that, they made a part payment of 2 crore.
Why this has become in process in that case? You have been paid half of the decretal amount.
Yes, Lord.
Decree is under challenge.
Here,
so why you have said it has become in process?
Lordship, I have not gone through this document. This is furnished to me right now.
No. Otherwise, also, forget about this. Forget about this. Why you have said it has become in process? Why you have agreed? According to him, since you have already received whatever amount,
yes,
you said in a particular communication that I'll not claim in future any balance amount. That's why I said its payment has been made wrongly, rightly, whatever. So
here there was a miscommunication between the council because I was of the impression that during pendency of RFA, some amount has been made. Because of that, only the matter become in process. Otherwise,
you have paid the half or full.
So for lawsuit, if lawsuit is degree lawsuit, the pending bills amount is 2 crore something. The cost has been 1 crore something. Cost has been imposed by the London Child Court.
Interest, not cost. Interest amount.
The cost of
Cost is 50,000.
Less than 50,000.
Cost of the suit is 50,000.
When these are lawsuit,
interest, what is the interest?
Interest in work was completed in the year 2000.
No, at the rate of
12% for a.
We'll make it 9 and cost will do away. Take it, pay it. That's all.
So then I pay lawsuit, the matter will be here on very low.
No, that's what I'm saying. Why you have,
My friend is changing the state lawsuit. That's the issue. And letter which I have produced.
But I had a doubt when you said that. That's why I asked you why substantial. Either it is in process or not in process.
Why I'm saying
what's substantial?
So on earlier occasions,
the
same submission was placed before his own conduct. Then lawsuit, they said lawsuit, some more amount is there lawsuit. Therefore lawsuit, it was kept pending. And then they filed.
You take instruction from your client on this basis, whatever is there. Why not? In that case, you just delete all this. We'll hear it. I think it's better.
Then
We'll
today
have
was
to-
the change of circumstances. So after the court, we just discussed, then it can be closed as in process. Therefore, I have submitted, it can be closed as in process. Now he is changing this system again.
No issue. We'll close it if you say so. We'll close it as in process. If you submit so.
No, the submission has to come from both sides of the court. It can be closed as in process on submissions of both sides.
Then what will happen?
Then was it is fulfilled. Then it will be deemed fulfilled also. This is a legal implication.
So he's not
No, no.
he's not saying so. Therefore, will not close it for as in process.
No. Then process.
See, if we held that it is in process, nothing survives.
Yes,
You may not have a right to claim again
yes.
because if you agree to that, right?
That's a legal implication.
The communication, Lordship, as I have submitted, the communication regarding influxes was made on the basis of this 2 crore only. But I was of the impression that because during pendency of this RFA, the department made deferred payment. For that purpose only, because
So according
since
to
they have
whether the part payment 2 crores or entire decretal amount.
2 crore part payment, entire decretal amount 4 crore, Lordship. Out of that 4 crore, they made a payment of 2 crore.
So we will hear that in that
2
case.
crore is remaining now.
What is IA is for? IA for?
I is calling for this original request because after
It has
during
been
pendency-
called.
The records which I have.
Okay. Records of what?
This
Records of
payment regarding
this
payment.
part payment and communication made amongst the department authority for payment of this remaining balance on also.
IA is for that.
Yes, for calling of all those original documents.
This one.
Yes, all these documents.
Do you have other document? This is just a communication.
Say what is, details regarding the payment made. So these are the details.
In my IA Lordship, I have called for 4 documents, Lordship. One is the certificate of payment on 23/6/2018, whereby an amount of 2 crore as part payment was made to me. And then thereafter again, there was an official communication letter dated 10/9/2021 between the executive engineer and the SE for sanctioning of the balance amount, decretal amount.
It was allowed or not?
It was communication was made between the department authority only, but till today, balance amount was not released. Page number 12 is the part payment certificate, Lordship. On 23/6/2018. This present RFA was filed on 4/9/2017, Lordship. During pendency, the department made a payment of 2 crore. 13 lakhs 77.
Annexure 1, 2, 3, 4.
Yes, Lordship.
You are supposed to bring on record by filing affidavit. You file it.
So for this payment is concerned, we pay those we receive, is not distributed. How it is?
No, there is a direction of this court to bring on record. The order that is 24/6/2024.
That is there. Then I'll file.
You file it. Bring on. In the IA, huh? Or Mr. K. Lalit Council, that you delete all earlier on for the applicant respondent. And also had Mr. Estep in London, senior government advisor for the appellant of the opposite parties. This application has been filed. Praying for calling of the records being annexed 1, 2, 3, and 4. Mr. This court on 24/6/2024 directed the respondent, opposite party, appellant opposite party
Certificate.
to bring on record to file an affidavit, bring in record, annexing the documents as sought for, as annexure 1, as sought for, as annexure 1, 2, 3, and 4. Mr. Estepin, the senior government advocate. Press for and is granted 2 weeks time to file affidavit as directed by this court by bringing on record of the above documents. There are 4 annexes you have to file annexes in IA. IA will dispose of the IA. IA is then disposed of, huh? Then in main, after 2 weeks, list the matter in main, huh? In the RFA, list the matter. This is the matter for hearing after 2 weeks.
Admission hearing.
We'll make it hearing. Admit, has it been admitted?
It's already
Admitted.
If it is admitted, why you should listen for?
because of IA lordship, it has come up in order again.
Yes. This for hearing after 2 weeks.
Deeply obliged.
Yes.
Well, in this case, on the last date, the status report which was called for was not received.
Okay.
This matter has been listed today.
What is the issue?
This petition has been filed for quashing of the FIR, which was
Offense?
filed under section 498A for domestic violence. The
Yeah.
dispute in between the husband and wife, they've already settled the matter. And there was a kabang also that was held, and in the said kabang, they've already settled their disputes, and both the husband and wife, they're living together.
T.Y. Bhutia,
Yes, Your Honor.
learned counsel for the petitioners, and also had MS. He's in a learned additional PP for the state. Office note dated 2011-24 indicates that reflects that the stated report as sought for has been received. Listed matter for admission hearing. After when?
After a week,
After when?
if you're
Mr. Tapin, take your this thing away.
What's my file in IA? Withdrawing previous IA
But he's
number
there.
207. Since the IA file IA number 207 was defective next year. We have inadvertently missed to comply with the
Well, not able to proceed. Heard Mr. This is IA 234.
234.
Mr. P. Gyati. Gyatso, sorry. Learned counsel for the applicant, public election petitioner. By by filing this application under order 23, rule 1, within bracket 3, bracket clause of CPC. The applicant has prayed for withdrawal of the introductory application number 207 of 2024 in election petition number 08 of 2024. The connected election petition number 08 of 2024 with a liberty to file first on the ground that the petition, the application is defective. Can it be allowed? Just because it is defective.
Very sure, but the whole IA was misplaced. The wrong, the wrong.
You have filed an objection. Otherwise, allow with the liberty. And Mr. Deepang, learned counsel with the petitioner, learned counsel for opposite party, being respondent.
Your Lordship, I'm for respondent number 3.
MS so and so. For respondent. There's opposite party oblique respondent number 1, huh? And MS so and so for respondent number
3, Your
3. There is no objection. Next, having considered the submissions and they are not being opposed by the, and not objected by the non-counsel for the opposite party respondents. The application, the present application is allowed, according the application number IA number 207 of 2024 is allowed to be withdrawn with a liberty to file fresh. IA is in disposal. Main case list after when? Not possible. I'll be away for 2 weeks again.
Documentation, my lord, your lordship will have to be present here.
This is the matter. Let us see, on after 2 weeks, let us see. Okay. When? We'll give a fixed date. If it cannot be
17th?
17th. 17, let us.
17th, Your Lordship, 17th December. Your Lordship, I have matters, the session quoted is on 17th, maybe fixed on.
We want to, this court wants to proceed further.
Yes, sir.
At least one petition, one petition.
There may be IS also now.
18.
18. With an understanding that if this court is not available, on 18, we'll list it.
Yes.
On VC, we'll take it up, but we'll list it.
Order.
List after someone.
Oh, bless you.
No one is there for other ceremony.
What is to be done? What is the matter?
My lord, this is for passing of order, my lord, for constituting committee
For what?
for settlement of land dispute.
Is there any surviving cause? Still, live issue to be determined in respect of what? For compensation?
No, ma'am. For ownership, ma'am.
Ownership.
Yes. Actually, my lord, it has been already decided by Kava, ma'am. But after that, this respondent side had filed appeal before ADC Mechuka, ma'am. And ADC Mechuka had upheld the decision of Kava, ma'am, in 2017. Thereafter, respondents they have again filed appeal before DC, ma'am. And DC had forwarded the matter to ADC Mechuka again. Again, then ADC Mechuka constituted board to settle the issue. That is the case. We are challenging that order.
You are challenging.
Yes.
Because there is no appeal. No appeal lies against the DC.
Yes, my lord.
What is the ground of appeal?
Ground of appeal, my lord. Respondents appeal, my lord.
Your appeal? No, your revision.
Yes, my lord.
What is your ground?
My ground is, my lord.
Ground of challenge.
That this matter has been already decided, ma'am, by ADC. Again, my lord, ADC is again deciding the matter after deciding matter in
Again?
Yes.
On and over and above his own decision.
Yes, my lord.
He has decided to go for
Another Kaba.
Kebab.
Yes.
Is there reason or
No, my
why
lord.
he has decided so? I think you may be correct. So without hearing the respondent, it
Yes,
will not be proper
Yes, madam.
to allow the review. But it's 2018 matter.
Yes, madam.
You inform him, on next date, no adjournment. Heard Mr. L. Nossi, learned counsel for the petitioner. Petitioners, only
Yes.
one. Petitioner.
Petitioner.
Non appears for the petition, non-respondent. Come on. Considering that the matter is of, considering that to afford an opportunity to the respondent, let this matter be listed after, let this matter be adjourned as a last chance. Listed accordingly. List the matter on after 2 weeks, 3 weeks, after 3 weeks. Listed, which is made clear that no further adjournment shall be granted on the next date, as the matter is of the year 2018.
My lord, interim may be continued.
Interim or the past earlier shall continue.
Obligation.
This case, my lord, hearing is concluded.
Yes.
And I have submitted my written argument.
My lord, I'm
Yes.
yes, I'm submitting my written argument today, my lord.
This is my lord, already I have submitted. In addition to that, my lord, today I have also submitted.
Additional, he had already submitted. Has he submitted?
Already I have submitted and today I have, my lord, submitted.
Where it is? Where is your written submission?
Already we have submitted before the.
This is my submission, my written submission.
What is it?
Yeah, me.
Where is yours? Heard Mr. A.K. Prakash, learned counsel for the petitioners. Both the cases, right?
Yes, my lord.
Together. And also heard. Would you say Advocate General?
Yes, Advocate General, my lord.
Madam, may I submit?
Learned Advocate General for the state, assisted by Mr. T. Tagap, learned counsel for the, learned standing counsel for
Education Department.
Education Department. Hearing concluded, judgment reserved.
Madam,
You
may I
submit, you submit it. You submit during the course of the day.
Yes, yes. Already we have submitted. I have, my lord, let me not have some.
You have filed it or you have just
I have already
submitted?
filed, because I have been told my junior, my lord, she has already filed.
You have filed before
Yes.
the court.
Yes,
You find out. In the registry you have filed.
before registry, I think, my lord.
I think you find out. You take with this.
If not, my lord, I will supply the copy.
If it's not, you submit it here.
And today.
If it
my
is
lord,
not, if it is not filed, you submit here.
Yes, and today, my lord, I have some additional judgment.
Yes,
That may be taxed.
take along.
Obliged, your lord.
Deeply obliged.
May I please, lordship?
Yes.
So first appeal, my lord.
Your lordship, my humble request would be conducting counsel. Right now he's standing on his leg at session court. Therefore, it's my humble request. Kindly, this matter may be taken after the lunch break.
Don't make a mention that, don't make an adjournment.
No.
Only
After the lunch break, this matter it's been fixed matter, so it's going to take long. Argument will be very vast. So kindly, this matter may be taken
What
after
is
lunch
the
break.
Regarding my lord, it's a suit filed by the appellant, my lord, for right title entries and recovery of possession, my lord. On that, my lord, there is an application under Order 39, Rule 1 and 2. The learned trial judge, my lord, initially, my lord, before that.
This is the last case.
My lord, before
Yes.
that, my lord, I would like to draw your lordship attention the office note, my lord.
Yes.
The office note dated 7/11, my lord. Now I have, my lord, check, my lord, the service has not been completed, my lord.
In respond number 3.
Respond number 3.
Who is respondent number 3? Who is respondent number 3?
Because I am.
Performer respondent. Heard Mr.
Shilarita.
Learned counsel for the appellant.
Appellant.
Appellants. And also heard Mr. K. Kambo.
M. Khambo.
M. Kambo. Learned counsel for the learned counsel appearing for Mr. Arsana.
Yes, on behalf of
Learned
Arsana.
counsel for the respondent.
Yes.
Respondent number?
You are for 1 and 2.
Respondent
Only
number?
1 or 1 or 2?
1 and 2. Office note dated in view of the service of in view of office note dated 7/11/2024 reflects that service report in respect of respondent number 3 is still awaited. In view of above, let this matter be listed after 2 weeks. After a week.
After 2 weeks, my lord, because and fixed date may be given, my lord.
After 3 weeks.
Yes. A fixed date may be given, my lord. And there is an interim, my lord, that may be continued.
List this matter after 3 weeks on 17.
17.
12.
Can it be 18 or lordship? On 18.
Make it 19.
19, it will be difficult for me.
18.
18.
We're fixing it on 18.
18.
Service report is awaited in respect of this.
And
It's a long time back. When did you take this step?
Immediately, lordship. Immediately.
Did you take fresh steps?
There was no order for taking fresh steps, my lord.
No, since the it's a has taken steps. Okay, on September.
Yes, lord.
Okay.
And the interim shall
18.
And the interim shall be continued.
Interim order passed earlier shall continue.
Lordship. Obliged, lordship.
18 we are fixing the date on because there's the service is not complete in respond number 3, right?
Yes.
All right.
Okay. Actually, I have to seek instruction from my senior counsel for fixing a date because.
But never take an adjournment or make a mention that your senior counsel is appearing in a court.
Okay.
In a trial court.
Okay.
Obliged, lordship.
Yes.
Keep the law.
My lord, postmaster on 24th of October, postmaster received my.
Yes, it's there. I see that. You sort it out. You'll sort it out. It's there. Your written argument is bigger than the two writ petitions.
Because I have submitted all judgment.
I'll rely on a few. Rely on the relevant one, not all the judgment.
It is up to your document.
Unnecessary. We're torturing the papers and inks.
I am not torturing you.
No, we are. All of us. If you refer all the judgment,
Yes.
it's amount to harassment and torture to the papers and ink.
It is a privilege of the court, court may rely or may not rely. Now you given a short note, my lord.
Obliged.
Sorry.